give them a chance to respond, and then collect some more. We have a question, 2 questions in the back. You can just identify yourself and give us your question, please.
Okay, thank you. I'd like to thank speakers for their wonderful speeches. Double thanks to Hazırol, I think. Yeah, sorry for the name. My name is Kerem Cem Sandım. I'm an assistant professor at Bilkent University. And my question concerns actually both speeches, I think. The last presentation, we talk about the connection between the unfair competition and competition law. However, I think we have just skipped an important point, and which was already in the slides. And you just mentioned about the banking case. And I think you referred to inducement to breach contract, which was governed in the Article 55 of the Commercial Code, which is, I think, very important. And it should be discussed. And the reason is that I think it contradicts with the competition law and competition policy to a certain extent, assuming that you take a literal interpretation of that particular provision. At least, I think, 2 provisions. I know that same provisions exist elsewhere, as in the US, tortious interference to contractual relations and business relations. And it exists everywhere in Swiss law, it exists in French law, etc., etc. Here, and I'll link to the other presentation. If you're talking about MFN clauses, and if you're saying that it's sort of creates incentives not to offer good prices, same thing happens with Article 55. So if you're dealing with, if you're saying that we need a guideline regarding MFN clauses because it disincentivizes me to offer good prices, what do you think about Article 55? How do you think we should deal with that provision? Because I think it's a real problematic provision. And I'm wondering the views of the audience and speakers as well. My view is negative, and I'm not going to go into detail with that, but I'm wondering about the views about that.
Negative in what sense?
I think it's really contradictory. It's a wrong provision. The economic rationale of unfair competition has 2 folds, I think. One, providing wrong information to the market and resulting in misallocation of resources. That's very clear in many provisions of the previous code. And it exists in a certain one. And the second one is free riding. So 2 rationales for unfair competition, not the third one. The current unfair competition law somehow injects protecting of competition, which I think contradicts competition law rationale, which contradicts with the protecting consumers. I cannot deal with that in economic sense. So I was wondering about your views. Thank you.
Maybe if we collect one more question and then have responses, and we'll have another round. I believe the lady in the back, please.
Thank you. Ayşe Gizem Yaşar, ELIJ Attorneys at Law, and I'm also an alumni of the Bilkent University Faculty of Law, and I'm very happy to be back. And thank you very much. I thought the speeches were extremely fruitful and I really enjoyed them. And my question will be to Mr. Gurkaynak, actually, as I can never find him to ask him my questions on a daily basis. Now, I believe that this paper on MFNs is very forward-thinking and the discussions are clearly very interesting and I really enjoyed reading it. But the thing is, okay, the cases in the US, they go way back. They go back to the 60s, but in Europe, this is still a pretty new discussion, and there aren't very many cases that discuss the competition law effects of MFN clauses. And we see in Europe, I know that I'm speaking on, on a Europe limited way maybe, but the guidelines are usually outcomes of cases, the case law that has piled up for many years. So how do we incorporate this discussion that has been going on in the US for so long to Europe and produce a set of guidelines that would answer the needs of the European market? Thank you.
These are two great questions. Elif, would you like to start on the unfair competition question, and then we can come to MFN, and Professor Pinar, you are most welcome, of course, to join in too.
Thank you. If I haven't understood mistakenly, you have mentioned that the relevant part in Article 55 is going against the competition law. Is that correct? Yes. Okay. Well, first of all, I think the I have also tried to mention while I was presenting that there are certain discrepancies, but the Turkish Competition Authority have also mentioned that a grammatical interpretation wouldn't be enough, and there would be some interpretation regarding the purpose, and we should interpret both the competition law and unfair competition law in a manner that would prevent prevent the creation of contradicting remarks in both. So I think despite the language of the agreement being on its surface against the competition law, I think the Turkish Competition Authority has made, well, it is not my place to judge it, but I think it made it right in interpreting it in a manner that wouldn't affect the competition law's application. So I think, yes, the language might be contradicting the competition law, but if you are to interpret it in a manner that wouldn't contradict with competition law, then you will have your answer, I think. Thank you.
Gonenc? Yeah, sure. Let me see the audience. So, two issues I have to deal with. One is the Article 55 question by Kerem Cemsanlı, and the other is the guidelines. How are we going to deal with it when there's not a stockpile of cases? The Kerem Cemsanlı question is, I think, a spectacular question. And it does actually melt into the MFN discussion very well. So I should say that as far as the Article 55 of the Turkish Code of Obligations is concerned, my academic view, and I am consciously picking my academic view because I had to defend otherwise representing the banks before the Turkish Competition Authority. But my academic view is that Article 55 of the law, the Code of Obligations, cannot be used in this capacity, and that there is a contradiction, and that that provision should not be there. So I think I can be as clear as possible in saying that there should not be a Code of Obligations provision that prohibits separately the inducement of breach of a law, breach of a contract. Because the breach of a contract in and of itself is a matter of Code of Obligations. I am extremely excited and I'm also extremely enthusiastic about whether Professor Gürzumar here would also chime in because we're squarely within his domains, both in Code of Obligations and also in competition law, and we teach competition law for more than 8 years at Bilkent University now, and it is very common that we don't have the same view, so the students are having a tough time sometimes. But my view is that about Article 55, hands off, there is a problem with the existence of this clause, and competition law should take precedence. Whereas when I am defending the banks and the Banks Association, I did take the following point, which I also believe to be true from an academic perspective. What I said to the board was that there is a supreme cause of compliance with the law. Hukuka uygunluk sebebi. So my view was that I'm not going to get into a debate of whether Article 55 should take precedence or whether the Turkish competition law should take precedence. But if my client is saying that they felt that there was a violation of the Code of Obligations and that's what they were enforcing against, then you ought to listen to this, because there is nothing to come up with against the will of the company. There is no place for an administrative monetary fine, because this is not the will of breaching competition laws. This is the will of enforcing another law. But very wisely, the competition authority in that case has asked, so how many cases have you actually enforced against these counterparts? They said, give us the statistics of there being court cases on this basis, and there weren't that many court cases. So one could say that the Turkish Competition Authority did do its homework and asked, believing in this defense, and the clients were not able to give hundreds of cases where this kind of an enforcement was going on. On the other question of Ayşe Gizem, I'm going to be quick about it to leave room for more discussion, and I see excitedly, I see that Professor Gürzumar would also like to contribute to this discussion, and I think there's more value in listening to him than me. The point of our paper is precisely that. So the point of our paper is there are some exceptional circumstances where you should not wait for a piling up of cases, where you should actually go in with your economic analysis. That's why law and economics are hand in hand. And to the extent academicians are able to point at a particular working of the marketplace where there is an efficiency to be attained and there is welfare to be maximized, then that welfare should be maximized as a matter of modeling and not as a matter of constant enforcement and waiting for the piling up of the cases, because that's not going to happen. Because you're in such a delicate field here that the market players are going to willfully prefer to not engage in MFN clauses rather than trying to understand the intricacies of when a particular MFN clause is problematic, when it is not. And to the extent you have guidelines such as after such and such market power, perhaps you should not go into MFNs because the burden of proof is going to shift, for example. You are going to be under the burden of proof to prove that your MFN clause is not hindering competition. That's a way of dealing with it. So at least you are rescuing the smaller players who are really doing it for predictability and for consistency in the marketplace. Or you could come up with the rule that you don't like clawback provisions. You don't like retroactive MFN clauses. But to the extent the MFN clause is in its purest form, then you're allowing it. So that's what we're trying to come up with this paper, is that a guideline is needed by way of operation of economics and contracts law and the nature of why contracts are brought up. Thank you.
Professor Gürzumar, and then Elif, please.
Thank you very much, Mr. Chairman. Is this switched on? Yes. Just a brief remark as regards to the question of Kerem Cemsanlı. This is a very delicate matter, I think, and it cannot be solved in 20 minutes during this session. But we have to overcome this problem. I mean, we cannot easily say that Article 55 of Commercial Code is in wrong place regarding the wording of breach of the agreements. And I agree with you, according to as regards to the legal policy, it's not correct. But no law order can accept any antinomies within itself. So the antinomies must be solved by the way of interpretation, of course. And when we say that in this case competition law prevails, then we have to add an element to that kind of statement, that only in this concrete case, because of those questions, we cannot generalize the interpretation. I think it's my personal thought, of course. It would not be appropriate, I think. But what can we do? As in the presentation of Professor Pınar and Elif Cemre Hazıroğlu, has shown the aims of the. I mean, there are no compartments of laws in a law order. We don't have competition law, obligation law, commercial law, and so on. So all of them must be in harmony. If they seem not to be in harmony, we have to do it through our interpretation. And I would, I could give an example depending on the relationship between antitrust law and intellectual property law, for instance. As far as I'm well informed now, the most accepted theory is the complementary theory between those two laws. You know, let's take the example of obligation to contract, for instance, and you have mentioned the freedom of contract too in your presentation. Obligation to contract or obligation to conclude a license agreement, for instance. The economists tell, I'm not an economist, tell that if, because of some externalities, for instance, the aim of efficiency, dynamic efficiency, is not feasible, then the allocative efficiency must take the place, and as regards to the allocative efficiency, the competition law can prevail and you know, force the owner of an intellectual property right to conclude a contract. And such a relationship must be seen between the competition law and unfair competition. Thank you very much.
Yes, please.
Thank you. If we can go back a little bit to Professor Sanlı's question, I have received some backup from Professor Pınar, so if I may, I would like to confer them to you. Unfair competition actually protects fair competition, and it prohibiting unfair competition wouldn't be hampering competition itself. And within the borders of, within the legal borders, the rights will be used. And also the competition law also prohibits when competition is restrained. And in Article 55, only the breach of contract, only the encouragement to breach of contract is being prohibited. And this article is new in Turkey, and it has been utilized in Switzerland and Germany, and it has its conditions. Therefore, it was implemented, and it was also progressed through the application by courts. And there are certain examples, such as when one of the parties oppressed the opposing party to cancel the contract. And in these cases, this part of the article comes in handy, according to my professor. Thank you very much.
Could we take a couple of more questions, please? Yes.
My name is Ahmet Fatih Özkan, and I am a PhD candidate at the University of Sussex, United Kingdom. Thank you for both of you for your wonderful speeches. First of all, I have two questions for both of you. Alumni of Bilkent University, that's right. I also had my master's degree in Bilkent University. And my first question is to Mr. Gurkaynak. And actually, I have two questions for him. Mr. Gurkaynak, are you suggesting a direct guideline that deals separately with NFN clauses, I mean a separate directive, or are you suggesting a modification or amendment to one of the existing directives or guidelines in the enforcement of Article 101 or Turkish national equivalent Article 4? And if so, I mean, if you are suggesting a separate directive, and do you think this subject is worth issuing a separate directive? And the second question is with regard to your terminology. Most favored nation clauses. The word nation, I think this word concept comes from international trade law. Wouldn't you think that it would be more appropriate if you formulate it as word most favored customer clauses? And for two questions. And I have one further question for the other speaker. And I had the impression that you interpret the relationship between unfair competition law and competition law mostly centered on Article 101 or Turkish national equivalent, Article 4. I would like to draw your attention to Article 6 or Article 102 of the EU equivalent. Would a practice on the part of dominant firm, let's say a practice that is normally considered as unfair competition law, deceptive practices or false advertising, ever amount to an abuse of dominance in this case? Thank you.
These are, well, let's take these excellent questions first.
Sure.
Gonenc.
Thank you, Fatih Bey, for these excellent questions. On the MFN guideline, about where we would like to see this guideline, first of all, the proposal of our paper is not that this is adopted by the Turkish Competition Authority. If that were to happen, it's fabulous. But I think, as I mentioned, it is best done by one of the locomotive competition law enforcers of the world. And when I say this, I'm not undermining the sophistication of the Turkish Competition Authority, but then it is a relatively young competition authority, and there are certain competition authorities that may have had a better opportunity to deal with this issue. And secondly, while Ömür Bey is also here, I should mention that the economic analysis journey of the Turkish Competition Authority is new. And we need a competition authority with sufficient resources of economic analysis to come up with this kind of a guideline, because it is going to be done basically on a modeling and on a review of the economic impacts of possible MFN clauses. So I wouldn't want a competition authority to blindly go in and take up some of the proposals that we have. We are mentioning certain things that we are suspecting is going to come out as true at the end of that economic analysis, but we need to see that that's what's happening. I would say that I would not want to broaden the scope of the guideline. So I would not want to say other arrangements that could be pro-competitive or anti-competitive, depending on the circumstances of event. And I would want to concentrate on MFN clauses. For example, a type of issue that looks like the handling of MFN clauses could be the pay-for-delay arrangements in pharmaceutical industries. Pay-for-delay is, you can compare it, pay-for-delay is also a very new phenomena. Pay-for-delay can be very delicate as well. So pay-for-delay, sorry, for the audience, is basically where there is a settlement between a pharma company that is the original manufacturer and the generics company. And bizarrely, I will say, the plaintiff of a litigation is paying the money to the defendant, and there is a settlement. And in that settlement, you suddenly see an extension of protection of time period for the patent. So basically, then you start realizing, as the competition authority enforcing it, that this is not a genuine settlement. What is happening here is that there were about 20 years of protection of patent on a given pharma product, and on year 18, suddenly there was a fake settlement, a bogus litigation, and then at the end of that sham litigation, a fake settlement, and that settlement was a conduit through which the protection time period of the patent was prolonged. Now, that could be the scenario, or it could be that this is efficiency enhancing, and it's a good thing, and settlements are to be to be supported. Again, as you can see, you are in a kind of an MFN world. But I would never think of coming up with a paper that says, let's come up with a guideline for pay-for-delay arrangements. And the particular reason why I would refrain from that is because every pay-for-delay arrangement really needs to be reviewed in its own circumstances, together with the amount that is paid and why that settlement has happened and all that. Whereas with the MFN, you really could memorize certain fact circumstances where it is really possible to say this part of it is not in the gray zone. To the extent you have these facts following each other, this is guideline material. So I think I'm not talking about all obscurities of competition law enforcement. As far as your question on terminology goes, I am actually in favor of an entirely different terminology, the terminology of Fiona Scott Morton of the DOJ, of the Department of Justice, who has introduced time and time again the contracts that reference rivals. So MFN is a subset of the type of a contract that reference rivals. To the extent there is a benchmarking of the rivals, I think we're looking at the types of issues that I am debating here. To the extent it's not price related, you could even be using the same guideline. For example, if the market power holder entity is saying, you're going to give me the shelf space that exceeds double the shelf space of my closest competitor. To the extent there is a huge market power with that party saying this, this could be a problem in terms of foreclosure and penetrating into the marketplace and making life difficult for the competitors. To the extent they don't have that market power, then that could just be that they are turning the shelf spaces into yet another proxy of competition, and that might be in need of enhancement. And all these could be dealt with under the name of contracts that reference rivals. If you were to be wondering whether it makes me concerned if someone were to say, rather than most favored nation clauses, most favored customer clauses, that's perfectly fine for me. I just adopted the term of art that has been used. So it is not a terminology that I am particularly willing to push forward or a terminology that I am feeling romantically attached to.
Elif.
Thank you. With regards to the abuse of dominance cases, I think this is an area where competition law is solely applicable, and when a firm in a dominant position commits a conduct that would institute an unfair conduct, then I think that would be the subject of unfair competition. So I think it's a matter of which one prevails. If there is a dominant conduct and an unfair dominant position and an unfair conduct is realized, then I think personally that's a matter of unfair competition law. However, if the infringement of law in general comes from the monopolist power, then it would be the subject of competition law. But as regards both of these having a common ground, I don't think so. I think we should pick and choose which one of these laws are being infringed and then apply one of them accordingly. Thank you.
Lunch is upon us. And I think it is it's a mark of again of wonderful research, scholarship, and forensic presentation that the audience will be chasing our panelists down for the rest of the day to pursue additional questions. Let me offer one comment on this fascinating discussion. And by the way, this is a universally significant discussion. As our colleague and I forgive me for forgetting your name, but as you teed things up, and in jurisdiction after jurisdiction, the relationship among contract law, unfair competition law, and competition law is a recurring concern, because few jurisdictions by statute have described the relationship. So as Professor Guzamar says, it's typically to the courts to try to ultimately define and redefine the doctrinal boundaries. Of the 125 jurisdictions that have competition laws today, over half of them do something other than competition law, and the usual portfolio of diversification includes something that's called consumer protection that often has an unfair competition law dimension to it. A trend in the future in many agencies is to bring hybrid cases that address the hypothetical that you just mentioned. That is to bring cases that straddle the two, in which the agency will bring a case that is based on a unified theory of exclusion, but it invokes both dimensions of the agency's authority. A great case that illustrates this was brought by the Canadian Competition Bureau within the last 3 years. It involves telecommunications. The name of the case is Rogers. The theory was the dominant incumbent telecom carrier, faced with entry by a new mobile carrier, began running ads that, it was alleged, misleadingly suggested that the new entrant had an unusually high level of disconnection rates. And it ran ads that said, if you use our service, you get good service. If you use the entrance service, you're going to lose all your calls. Their coverage is bad. The Canadian Bureau said that was a lie. That was misrepresentation. And it had a deliberately exclusionary purpose and effect, so that it used the unfair, the misleading advertising as the dimension of the abuse case, basically. The Canadian court did not find ultimately the advertisement to be misleading. That is, it rejected the factual assumption of the case. But I think it exemplifies a type of case we are likely to see more of, if only because so many authorities around the world, by my count, over 60, have this dual role mandate, so that you are likely to see some osmosis across the boundaries. So the presentation and the topic, again, is exactly on the leading edge of conceptual questions that are going to show up again and again. Please join me in thanking our presenters for these wonderful talks.
Distinguished guests, now we will have a lunch break. You are all invited to the Ankara restaurant on this floor, which you may find following the signs. The next session will be in the Izmir Conference Hall with the keynote speech of Professor William Kovacic at 1 p.m.
You better show up for that.
Thank you and bon appetit.